Good evening, everybody. My name's Daniel Monk. I'm one of the professors in the law school at Birkbeck, University of London. I think most people here are students at Birkbeck, but I know we have a few other people who aren't. So those of you who are thinking of coming to Birkbeck, welcome, and I hope you enjoy this evening. Um, this is the 25th legal practice conversation that we've had at Birkbeck. They started in 2012. I looked it up this evening. I can't quite believe that it goes back that far. And the point of the legal practice conversation is it's an opportunity for someone like me who teaches and writes about law to talk to someone who's a practitioner in law, who actually is involved with the day-to-day running of law, involvement of law, right on the grassroots of it. And that conversation is quite fruitful, and I hope you're going to enjoy this evening. I'm absolutely delighted to introduce our speaker this evening. My person who's going to be chatting to me is Pauline Troy. And Pauline, welcome, welcome. Thank you for joining us, Pauline. It's great to see you.
Thank you for inviting me.
Not at all. And Pauline is both a solicitor and a barrister, or rather was a solicitor, is now a barrister. So for all of those legal system and method students who, in I think a few seminars ago, we agonized over what the difference was between solicitors and barristers and got quite confused at times, Pauline's definitely going to help us
I don't know, I
explain the
find it
differences.
confusing sometimes.
It is. I mean, it used to be very straightforward, and it really isn't that straightforward anymore. So it's really great to have someone who's been both a solicitor and is now a barrister. That's great. Um, Pauline works in the field of public child law at One Crown Office Row, great barristers' chambers. And what we're going to do this evening, just so everybody knows what the plan is, Paul and I are going to have a chat about all sorts of things about law and Pauline's role. Then we're going to talk about a case which I think you've all been informed about. And it was a case that Pauline was actually counselling, was involved in. It's a fascinating case. And then at the end of the evening, there's going to be lots of opportunity for all of you to ask questions. And the way in which we're going to ask for you to ask your questions is in the Q&A. So at the top of the screen, you'll see a Q&A box, and that's where you can put your questions in as we go on. So I'll be keeping an eye on that as well. But over to Pauline. So Pauline, welcome. I think I'd like to start by asking, what made you want to become a lawyer of any shape or size? Before we get into the solicitor barrister thing, what made you want to become a lawyer? Why law?
It was a total accident, and I'm sure you must hear many, many people say that, but it really was in my case. I went to a normal state school, a grammar school. I did my A-levels. That was 1982, and I decided to take a year off. And unlike many of the peers that I met when I arrived at university in Exeter a year later, I didn't spend my year off doing anything particularly glamorous, travelling the world. I went to Peckham, which was not the glamorous Gigi place it is now in southeast London. It was quite a rough part of town. I worked in Peckham Town Hall and accidentally found myself in their legal department. And I was working as what's called an outdoor clerk for a year, and was very lucky to find myself in the public law children's team, the team dealing with child protection cases. And I've ended up specialising in that field in my career, both as a solicitor and as a barrister. So it was a total accident. I'd already applied to university when I got the job and wanted to do English literature. I transferred in it was called UCCA in those days, UCCA process, to do law, and ended up at the University of Exeter. where there was lots of really clever people, including, I think, one of your learned colleagues, who was a couple of years behind me, I think. And yeah, the rest is history, as they say.
Well, it's really interesting that your first experience of law was working in a local authority, because I think people often
Yeah,
forget that it's a really great place to learn about law. I mean, they're involved with so many
absolutely.
issues of laws. Did you ever think about wanting to become sort of an in-house local authority lawyer?
Happily not.
Why
And
happily not?
well, I did enjoy it when I was not an article clerk, an outdoor clerk, because it involved a lot of running around. In
Yes.
those days, local authorities, when they were taking what we now understand to be care proceedings, the Public Law Children Act proceedings, a lot of it was wardship, which is where we're going to end up discussing
Mm.
later on. So I found myself zooming around in London, going to the Royal Courts of Justice as a sort of bright-eyed 18-year-old, and just really enjoyed it. And I discovered there's this place called the Temple, which I'd never heard of before, and yeah, just really, really loved it. And I've never really looked back, to be honest.
I remember doing a bit of outdoor clerking, and there was a lot of running around the Royal Courts of Justice and
Mm,
having to get forms stamped by quite scary people called
yes,
masters in the Royal Courts there who were
yes,
terrifying, weren't they?
yeah, yeah. I remember there was a real Rottweiler battle axe High Court judge called Mrs. Justice Heilbronn, who,
Mm.
well, I think she was one of the first, certainly in the family division, female High Court judges.
From
But
Liverpool.
yes, they were. A lot of them were really quite fierce and scary.
And Fleet Street was quite different then as well.
It was, yeah, very
Different
much so.
atmosphere. Well, I want to come on and talk about the culture of the bar, which does over in a moment. But um, I want to think about, your role first becoming a solicitor and
Mm.
what you liked about being a solicitor, and then why did you want to become a barrister? Because that's a really interesting change. So perhaps to talk us through that. So you started as a
Okay,
solicitor. Where did you first work as a solicitor?
I did my articles in a high street legal aid practice
Right.
in southwest London near Clapham Junction.
And
And
articles, just a second, articles for everyone listening, that's kind of what's now referred to as trainee solicitor, isn't it?
yes, it
Yeah.
is.
When we
So
did it, it was articles.
in those days, you had to do four different heads over 6 months each, or a combination of them over the 2 years. And so mine was a high street legal aid practice. I only ever wanted to do legal aid work. I wasn't interested in going out and earning lots of money in the city. I wanted to do interesting work about real people. And I was very fortunate at different times in my career because there were different social changes going on that had a real impact on the work that I was doing. So, for example, um, I did crime in my articles. So I started my articles in '87, and the Police and Criminal Evidence Act was passed in '84. The Crown
Mm.
Prosecution Service was set up. Duty solicitor scheme was set up. So I did a lot of duty solicitor covering work. At the same time, of course, this was Thatcher's Britain, and there was a lot of social change. She abolished Rent Act tenancies and things like that. The Housing Act came into force. There was a lot of work to do to protect tenants who were being thrown out of their properties by really unscrupulous landlords. So we did a lot of work negotiating fair settlements for tenants who were being evicted unfairly.
Mm.
Another fortunate thing that happened as I just qualified, the Children Act was passed, '89. It didn't come into effect until 1991. But of course, I'd been qualified as a solicitor for 2 years by then. And when you are newly qualified, you probably spend the first couple of years sort of finding your feet, deciding what you want to, what area you want to work in. You're still being supervised, or you should be.
Mm.
Um, and yeah, just at the point where I was saying to myself, I really want to do it. I really want to specialize in children's law. The world changed for everybody, and suddenly all what everybody knew under the previous schemes of wardship and other legislation really went out the window. And in 1991, it was a bit like the Wild West because nobody knew
Yes.
anything. And I can remember one of the first cases I did. In fact, it was the first case I did under the Children Act. It was a case where a child had been murdered, and you had to start the proceedings in the family proceedings court, which was just the magistrates' court.
Mm.
And me and my opponent said, you know, we've got to get this into the High Court. We can't be faffing about in the magistrates' court dealing with a case so serious. And we thought that transferring it to the High Court via the county court, as it then was an absolute given, and were gobsmacked when the court actually refused the application to transfer it because the clerks of the justices have decided we don't want to be seen to be turning work away. So we then had to work out how on earth are we supposed to appeal this decision on the day that the Children Act came into force, and then
Gosh.
realised that there wasn't a form to make an application to appeal because nobody thought of the fact that you might need an application form. So we literally had to make it up as we went along. And you know, it was great as a new young person to
Yeah,
be in
it
the
really
same
is.
boat as people who'd been qualified for 20 odd years.
Yeah,
Nobody knew what on earth it all meant.
yeah, the Children Act 1989 was an extraordinary piece of legislation. I mean, it's
Yeah,
still referred to as something that, there was such a total game changer, wasn't it? And then we'll come
yeah,
on to why it mattered a little bit later and why I
yeah,
think it's a really interesting piece of legislation for everybody, not just child lawyers, actually, because in
yeah,
terms of the principles underlying it, I want to just
yeah,
ask you some specific questions, Pauline, about what it was
yeah.
like. What was the size of the firm you were in when you were
When I
first
was a
went to a solicitor?
trainee, yeah, well, when I was a trainee, it was a firm. It was three offices in West London, one North London in the Harrow Road, one in West London in Fulham, and the one I was in was in South London in Battersea. And it was really a real high street firm, as I say, lots of duty solicitor work. Really, they did anything that came in off the street, and legal aid was properly funded then.
Right.
So there was none of this, you know, you can't do this type of work because there's no such thing as legal aid for, I don't know, welfare benefits or something like that. We did everything. And I'm quite proud of the fact that we were really able to offer that whole holistic service, a bit like a GP,
Yeah, I was going
because
to say, would you say it really was sort of high street GP? I mean, in a sense,
it
that was
really
the
was, yeah,
model of what, when people sort of described sometimes the old distinction between barristers and solicitors, the old idea was, well, solicitors are kind of like the GP on the high street and the barrister is the specialist. That
yeah.
description used to sort of work, didn't it?
I think it does. I think it did.
It did, didn't
Um,
it? I'm not sure
it
it does
depends
anymore.
on it doesn't in the work that I do because I think what happened then in the 1990s is the Law Society introduced all these accreditation schemes.
Hmm.
So in order to represent children in care proceedings, you have to be on the Law Society Children Panel. I think they call it something else now,
So, in
but
a sense, just for everybody who won't know what that means, in a sense, it was
yeah,
introducing a system whereby lawyers were required, solicitors were required to be specialists. You had this
yeah,
specialization emerged. So, the idea
yeah,
of just being the GP model didn't work because they all had to specialize. So, I
yeah,
remember going to see a GP sorry, not a GP, going to see a solicitor on the high street who was going to do a bit of conveyancing and thought they could then write a will and say, no, 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 we can't do that. So the idea you'd have that, the word you used was that holistic model of legal services kind of went out of the window because all the solicitors had to specialize.
Yeah, and I think also from, public protection point of view, it's entirely the right approach. So, I mean, when I qualified as a solicitor, I left the firm that I did my articles in, and I moved to a firm in Croydon. And I ended up staying there for 22 years. And so I joined there in 1989. I was made a partner in 1992, and I was an equity partner from that point onwards. So effectively, it was partly my firm. So it was a
Yes.
bit awkward to leave, even if I wanted to. But so that firm, when I first joined it, there was me and another guy who was a legal executive, but he was doing the solicitor's exams. So he became a solicitor after I think about a year later. There were two solicitors who were the partners, and I think another legal executive. So there's about and there was a guy doing conveyancing. There was about 6 or 7 fee earners. Everybody had their own secretary in those days as well, because nobody could type.
No.
And there was no such thing as emails or anything like that. All the correspondence was we'll expect a reply in 2 weeks and things like that. Um, and then gradually the firm expanded, and by the time I left, we had 3 offices and about 70 odd staff, and it is one of the biggest firms for crime, doing really big heavyweight crime. And family, basically. But what I think, just coming back to the point we were making about specialisation, when I first joined my firm, people were still trying to, if you had a client who was a criminal who'd been arrested for something, they come into the office and they'd say, oh, I'm really, really upset because my missus won't let me see my daughter anymore. The criminal lawyer would automatically want to try and service that as well. And it became particularly tricky, I think, in circumstances where the basis of the criminal case also was a child protection case. So, say, for example, you've got a criminal client who's been arrested for cruelty to a child. That's obviously a matter that the criminal team should be dealing with. But there's also then the issue of child protection, which the family team should deal with. And it's really important that people don't try and do both, because the rules in relation to these disciplines are so different. I mean, just by way of one example, in care proceedings, if we instruct an expert, we have to disclose that report. You can't sit on it because the court needs all the information to make the right decision that's safe for the child. The child's welfare is the paramount consideration. In crime, if you instruct an expert and you get a report that is not helpful to your client, you don't have to disclose it. So there's already a conflict in terms of the rules, basically. And sometimes I think people who try and dabble in both find it difficult to, separate those things out.
So as you said, the rules were introduced. One of the rationales for them was a kind of a quality protection for individuals, and it certainly satisfied that. I suppose, coupled with the idea that they become kind of businesses in a way, and with the removal of legal aid, it actually means some aspects of people's lives, they actually find it very hard to get the advice they need. I remember looking at one case. It was a young man, and it's quite school age. And it was an educational issue because he'd been excluded from school, which was public law. He had also been arrested for something, so it was criminal law. He was homeless. His family were homeless. They needed housing law. And there was child protection lawyer. And there wasn't one lawyer dealing with it. You actually needed at least 4 lawyers to deal with
Yeah.
what was going on in this boy's life. And it was quite hard
Yeah.
to explain that actually there's all these bits of law going on in this guy's life. So it can be it's quite tricky, isn't it, in practice? But I want to move on, Pauline, to ask you this. There you are, you're a partner in a law firm that's expanding. It's an exciting moment. And
Mm.
then you decide you want to become a barrister, move over to the other side. Talk us through that.
Well,
Why did you want to
what
become a
happened
barrister?
was, yeah, I mean, as a solicitor on the children's panel, you do a lot of advocacy yourself. And so the boundary between being at the bar and being a solicitor in terms of advocacy becomes quite blurred.
Yeah. I mean, I think just to
And
stop you there, I think in a sense, I mean, I
mm,
think it's really important to emphasize to people, most advocacy is done by solicitors, if you think of all
yeah,
the courts. So, the idea that solicitors aren't advocates just isn't the case.
no.
Back to you, yeah.
And I think when you're a partner in a firm of solicitors, you've got so many other responsibilities as well. Ultimately, you're responsible for other people's jobs. You're responsible for the training of your staff. You're responsible for recruitment. You're responsible for contracting with the legal aid agency. Um, you're responsible for the premises, people's practicing certificates, their training compliance, all these things, and basically running a business.
Yes.
Whereas the core, the pure lawyer bit, which is the bit that I like, really has to take second place sometimes to doing those things. Also, as a solicitor, certainly doing the work I do, you've got to run the files, you've got to prepare the
Mm.
statements, you've got to see the client, you've got to be available to deal with people's queries. You're probably running about 30 odd files at any given moment. Whereas at the bar, you are literally removing all of those other distractions because you're not running files. All you're doing is each case that you've got in your diary the next day. There
Mm.
might be some cases where you are retained for a period of time. There might be cases where you've got to do a week's preparation because you're dealing with a 3-week trial that's got umpteen different eminent King's Counsel against you, which happened to me recently. And you simply haven't got the time as a solicitor to really sort of scale back everything to be able to do advocacy on that level. But that's not to
Mm.
say there aren't very good solicitor advocates. There are, but they have to structure their careers so that they're freed up to do that level of advocacy.
Yeah.
Otherwise, they do lots of sort of administrative hearings. But you couldn't expect a solicitor to take, say, 2 weeks out of their diary to be in court
No.
day in, day out, and not have anybody behind them to service the clients who need day-to-day care.
And as
So
you
it's
said, being a solicitor as a partner, you're actually managing a big firm in a sense,
yeah,
which
you
and
just
as a
can't do it.
barrister, you're self-employed.
Yeah, well, yes, exactly. I mean, I was self-employed as a solicitor as well, but as a barrister, you are completely autonomous. So although in our chambers we've got, actually Melissa can tell me if I've got this wrong, but there's probably about 60 odd barristers in the two teams in our Brighton annex. We're based in Brighton, whereas Crown Office Row's also got an office,
Yes.
chambers in London as well. And each individual person is an entity in themselves. So we share our resources, we share our premises, we share our clerks, we share our contacts, we cover each other's cases if somebody can't cover something to keep it in the team. But I mean, like for example, today, a hearing I've done today, there were 3 other members of Chambers and me all on the same case, fighting our respective clients' corners.
Mm.
So yeah, I mean, I suppose for me, the liberation or that sense of complete independence and autonomy, it's just me. I'm not responsible for anybody else is, lovely compared to have what became like an albatross around my neck,
Right.
albeit a very successful firm. Um, and I think ultimately, at the end of the day, I just didn't really like my partners. So that was that.
And did you enjoy, I mean, and as a barrister, you hinted it before, the sort of sense that you get to do more law.
It is. It's all about the law. Compared to being a solicitor, it's all about the law. So I've read more cases and
Mm.
learned more as a lawyer since I came to the bar than I ever did as a solicitor, because as much as you try your best to keep up to date with absolutely
Mm.
everything, things just aren't crossing your radar in the same way if you're sitting in an office preparing a statement for a client, or
Mm.
dealing with some recruitment issue or whatever it may be. It's just a different approach, I think, or maybe it's just me. I don't know.
Do you miss the sort of the personal contact with clients?
No, I do a little bit. No, I mean, to be honest, you do, and obviously you do get contact with clients doing the job as a barrister as well. It's
Right.
not the same because it's so much shorter and sharper, if you like.
Yeah, so could you explain the different relationship that you would
Yeah,
have with the client as a solicitor and the relationship you have with a client as a
yeah.
barrister? That would be
So
helpful.
as a solicitor, you'd client would come in off the street, um, and let's say it is a care case. Um, you take their initial instructions. You prepare. I probably would have gone to court with them myself for the first few hearings. So you try and sort of build up that relationship, um, and then you see them maybe a couple of times a month, depending on how intense the level of work you needed to do, preparing statements, organising experts. And in big cases, I would have been instructing counsel, so having conferences with counsel and stuff like that. The whole process in those days would probably be going on for about a year potentially. So you'd have
Mm.
quite a lot of contact over that period of time. I found working in Croydon that there was a lot of communities that you would get work from. So, for example, if I'd represented, say, a brother, and he had,
Mm.
his girlfriend's brother was, or girlfriend's partner was whatever, you'd have these links that you do one case and then you get a referral for another one. And so it would go on like that. And I used to be able to, I don't know, it's difference between being 30 years older now, but I used to be able to remember really, really clearly the details of how these different family trees would work together. So I didn't always have to do a conflict search because I would remember that
Mm.
5 years ago I'd done this case, and therefore that person, I couldn't deal with that person because I'd already dealt with this person, kind of thing. I think because you have much longer, more intensive contact with clients, you just remember it more in a more detailed
Mm.
way. Whereas at the bar, again, obviously being older, I suspect the memory isn't what it used to be. But also, I think your brain works in a different way. I have to remember things really intensively for a very short period of time. And it's almost
Right.
as if you've got like a delete button in your brain to empty out what you did last week so that you can fill it up with what you've got to do this week. And so quite often I cannot remember for the life of me what I did last week.
Yeah.
And without looking at the diary, I would be
Yeah.
thinking, well, where on earth did I go last week? You just can't remember it. It's really weird.
Right.
Whereas as a solicitor, I think it is to do with that level of contact. You're seeing these people so many times and you get to know them really well. I mean, also in care proceedings, when you're acting for parents, you often deal with successive children for the same
Yes.
person. I've had cases where people have gone on and had 6 or 7 kids and you've dealt with all of them. It's
Mm.
it's very distressing from that point of view.
Yeah. Yeah. So being a bit, and your clients at the moment, I talk about, these people being your clients. Presumably, it's the solicitors. So who's instructing you now? Who are who would
Oh,
you call your clients?
I deal with, I now do a lot of local authority work, which I'd never done between being a student and coming to the bar, because in private practice, you're literally just acting for the parents, the children, or other family members.
And
Never
if the
did
local
any local
authorities
authority
on
work.
and the local
Yeah,
authorities on the other side, right?
yeah. So the local authority generally is an in-house team, but actually in Sussex they do occasionally delegate their work to agents depending on how busy they are. So there are some solicitors in private practice who do local authority work, but I was never one of them. And in fact, since I transferred and when I was in my old chambers, I suddenly started doing almost exclusively local authority work, which I have to say was a bit of a shock. But professionally, it was a really good experience because um, it's the only way I can explain it is that it's really, really much harder to prove a case than it is to undermine it. So to suddenly be in a situation where you're in charge and you've got to think, well, how on earth do I prove this particular allegation?
Right, right.
What evidence do I need to prove what I'm trying to assert? Because the burden of proof is on the local authority,
Yeah.
albeit on a balance of probability. Whereas when you're acting for a respondent, a parent, there's all sorts of, you know, ways in which you can undermine what the local authority is saying,
Mm.
such that they can't prove their
And
case.
are there
And
And Pauline, are there people in your so in the criminal law area? I know there are sort of lawyers and barristers who say, "Well, I'm always going to defend. I never prosecute. I
mm,
always defend." So I'm just curious to know whether actually in the child law area, when children are being taken into care, do you often also just find people saying, who will only do one and not the other?
there are some, they're very few and far between, and they're mainly at Garden Court, um, as one might expect.
Well, do you want to
But
explain that? What do you mean by that?
well,
Do you want to explain what you mean by that?
Garden Court is a wonderful set of chambers that have got a reputation for being very, very left wing. They tend not that they do, for example, local landlord and tenant work. They'll only ever act for tenants. If they
Right.
do crime, they'll only act for defendants. If they do children's work, they'll only act for parents.
Mm.
I mean, I'm not saying that across the board, but there
No.
are
Yeah.
people who have got that social conscience, and
It's the sense of standing up to the state. It's sort of being
exactly
the
because
individual against the state. Obviously,
yeah,
obviously, of course, in child protection area anyway, just as you said, just acting for the parent does, beg the question, well, the local authority are, standing up for the child as well, aren't they?
yeah,
So it's,
exactly. And I mean, I've actually tried my best, and I think the case that we're going to talk about is one
mm,
in point where I'm very conscious when I'm acting for a local authority that I am representing the state in a human rights context in
yes.
circumstances where the local authority have got a duty to be fair, they've got a duty to act proportionately, they've got a duty to respect the private and family life of the family members.
Mm,
So, I mean, I think it's actually quite important that there are people who are conscious of that acting for local authorities because,
yes.
sometimes you do have to try and rein them in a bit. But not very often in my experience, but nonetheless, you don't want people getting carried away.
Yes, yes. And as I said, I think it's a bit more complicated in these cases somehow than just,
Yeah.
the state, because it is the child who's being protected. The child's
Yes.
interests aren't necessarily the same as the parents, quite clearly.
No.
So I
And
want to
some,
ask you yeah, sorry,
I was just
Pauline.
going to say, some of the cases that we deal with, like the deprivation of liberty cases,
Mm,
everybody is just, scratching their heads about how on earth they can keep this child safe.
mm.
And at the same time, come up with a scheme of protection that is proportionate, even though it does mean that their liberty is restricted,
Yeah,
which is Article 5.
there've been some really upsetting cases in that area.
Mm.
Mumby's judgments in particular,
Yeah,
pleading to the politics and law really got blurred
yeah,
there. I,
exactly.
I just want to ask you a couple of questions before moving on to look at the case.
Mm.
Um, just teasing out a bit more this difference between solicitors and barristers. One of the public perceptions of people of these two very different careers, I mean, there are a lot less, there's loads of solicitors and there's a lot less barristers, is that the
Mm.
bar and barristers' chambers are stuffier, more elite, posher, and that there's almost like a class divide between them. And
Mm.
what's your thoughts about that?
I think, well, Melissa would be a good person
Mhm.
to answer that in a moment because
Great.
obviously she's a pupil now. But
That's great.
certainly back in the 1980s when I was doing my training, it never even occurred to me to apply to the bar. I just thought it was completely out of my league. I was a South London person with a gall-blimey accent. I couldn't see
Right.
myself being in that situation. I think it's much, things have got a lot better. There's no doubt about it. Our chambers, I don't think is at all stuffy. I hope Melissa's agreeing with me there. And I think, the we do need better diversity. There's no doubt about it. And I hope that people who want to apply for the bar don't feel constrained in doing so.
Yeah.
Um, but I think it does take quite a strong character to get through the process that I know Melissa's going through. And
Yeah.
obviously, my experience was totally different. The only thing I had to do to transfer was eat 6 dinners
Right.
because I already had higher rights of audience as a solicitor.
Yes.
Um, and I already had a reputation. So, when I first started at the bar, I was effectively carrying on with cases that I was working on as a
Right.
solicitor anyway.
Right.
So I could hit the ground running in that sense.
And two more questions about legal personnel. The role of the barristers' clerks has been sort of much discussed and written about. And, even I've got friends of mine who are barristers, and I talk to them saying, well, I'm having trouble with my clerk. And I know someone who's often moved chambers because they thought their clerk's not giving them the best work. And they went to chambers who were very happy because the clerks were giving them better work. Um, so that whole role of the clerk as being a sort of a gatekeeper for work, how does that work out, Pauline?
Well, to be honest, I don't really understand it myself.
Okay.
Um, and it, I mean, certainly in our chambers, I think we have a very fair system of how work is distributed. And in my previous chambers, they were very keen to make it as transparent as possible. Um, but I think that I suppose where we are down in Sussex, it's a provincial area. Everybody knows each other. Um, I've not noticed anybody particularly being short of work. And as I say, in the cases that I do, I'm regularly appearing against colleagues from chambers in the same case. So I'm not aware of there being any problems with allocation of work. And also, the further you get into your career, of course, solicitor clients will phone up and ask for individuals because they know
Right.
you.
Yeah.
Um, so, I mean, really, the way that you build up your reputation is by getting to know people, I think. And
Yes.
I've thought of something else actually that I was going to say earlier, Daniel, about the difference between the two sides. Where things are blurred in the other way is that a lot of a lot of barristers now do public access work, direct public access work without a solicitor involved. And
Mm.
basically, I did do a bit of that when I first started at the bar, but I got terribly confused because it was so similar to the role of a solicitor, and yet there are restrictions on what you can and can't do. So, for example, barristers aren't supposed to, unless you've done an extra level of training, you're not supposed to engage in litigation, which is things like sending correspondence and stuff like that. And it's
Yeah.
also a bit of a pain because you end up having to prepare bundles and things like that, which is really what the solicitor would do for you when
Yes.
you're at the bar. But so
Yeah.
so the fusion or the fusion of the roles is sort of comes at you from both sides. It's not just
Yeah.
solicitors doing advocacy, it's also barristers doing direct access work.
Yeah. You've mentioned your chambers, and that's the word to
Mm,
describe where barristers, the barristers, collective offices.
yeah.
How much are you actually in chambers? And I suppose what I'm getting at there is kind of, how much is your life online now professionally?
Well, when I was at my previous set, which is 42 Bedford Row, which is in London, bearing in mind I'm about 10 minutes from the sea in Hove at the moment, I hardly ever went to chambers when I was at that set because all my work is based in Sussex. So now I spend quite a lot of time in chambers because I walk to court in Brighton and I walk past chambers to get there. So I like to pop in for a cup of tea and things like
Right.
that. So I spend
Right.
actually more time in chambers now than I ever did. And I really like it because it's nice to sort of hang out with people. Um, yeah, it's a nice atmosphere.
So, but you don't need to for the actual
You don't
job.
need to.
No.
No,
Okay.
absolutely not.
And
And I was
how
not
often
at
are
any
your yeah.
disadvantage by
And how
not
often are
doing it when I
your
was in London.
and how often are your court appearances online now?
Hardly ever.
And that's
Um,
because it's child protection work, yeah, which is
well, it's because, yes, I mean, they prefer to do it in person. We do
mm,
occasionally do it online. I mean, for example, I had to do an out of hours hearing on Friday evening at 7:30 at night, and that was on the phone. Um, but we've stopped doing um, remote hearings unless, I mean, if it was a hearing where the parties didn't need to be there and it's just a sort of administrative thing, we probably would do it online, particularly if the judge is in Hastings and everybody else is in Brighton. Um,
mm,
but if it's a hearing with clients, we tend to do it in person because a lot of these people haven't got the technology.
no,
And there was a real issue during COVID about whether or not people had access to justice because they didn't have, if they had a phone, they didn't have credit. They often didn't have the privacy. I mean, I remember doing a hearing with a guy who was a HGV driver of a lorry, and he had to pull over on the hard shoulder on the M25 and do a hearing and
mm,
listen to his children effectively being removed from home over the
mm,
telephone. It's just terrible.
yeah,
So we
yeah,
try not to do it if we can avoid it.
yeah. Um, I want to move on to talk a bit about the case.
Mm,
And this is the West Sussex County Council versus Kay case from
yeah.
2022. And I just noted, as a really fascinating case to read, that the judge in this case singled you out in paragraph 6 for your particularly skillful contribution there.
he's
So that's
he's a
very nice.
lovely man.
Yeah,
Bless him.
yeah. Yeah, it's a nice one. Well, I'm just going to ask a quick question about that. When I was doing some interviews with family judges, I remember for some research, and some of them were saying, well, I would make this decision. You go down the corridor and talk to my other judge, and they probably wouldn't make that decision. So he said,
Mm.
he's a lovely man. I want to pick you up on that. He's a lovely man. And I think, that judge, he definitely is. But suggest they're not all. And how much difference do you think it makes?
Oh, in Sussex, they're all lovely, I should add,
That's
which is one of the
CM, isn't
reasons
it?
why I can't be bothered to go anywhere else. No,
Right.
I mean, everybody loved Judge Thorpe, though.
Yeah.
Sadly,
I
he's
know.
retired,
Yes.
retired relatively early because he was profoundly deaf and he set up the court with this wonderful hearing loop. But during COVID, he had to concentrate so much just to, because he couldn't obviously use the court
Mm,
system very easily. He was just worn out, bless him, by the end of the day. So he retired about
mm,
2 or 3 years ago now, but he was everybody's favourite judge in Sussex because he was so clever, so fair, so
Yes.
pleasant. But yeah, all the judges in Sussex are lovely. So if anybody who's on this call wants to think of a place to practice, I would suggest Sussex.
Yeah, no, it is important to think of outside of London. You know, there's a very different
Yeah.
atmosphere at the bar and place. I've heard that from lots of
Mm,
people. But back to this case. Now, I'm conscious we've got lots of people on this call, and lots of them aren't child lawyers or wouldn't know it. So we can't get
mm.
into too much technical difficulty. So I'm just going
Oh,
to
good. That's a
sketch.
relief.
Oh, I'm still going to ask you, hopefully, a
Oh,
search
God.
question. But for people who aren't there, you know, there are lots of what was interesting, I thought, about this case is everybody agreed that this child needed the local authority to be involved in the child's life. There was no
Absolutely.
dispute about the facts are very tragic, very simple. The father was dead and the mother had had this horrific accident and she didn't have any mental capacity herself. So there was no question that she wasn't going to be able to do the parenting. And everybody agreed about it. And everybody agreed that the local authority need to be involved, and child protection proceedings of some sort were required.
Mm,
So it wasn't the tradition, the classic kind of child protection work where you've got a parent on the side saying, no, my child shouldn't be taken into care, or no, my
mm,
child shouldn't be adopted, and you're
mm,
navigating that kind of competing interest. It
mm,
wasn't like that at all. It's something quite different in this case, which makes it really interesting and makes it very, back to what you said before, it's really legalistic, this case, because there are
mm,
lots of different ways in which a child can be looked after or protected. It can be foster care, it can be
mm,
accommodated via Section 20, it can be a care order, it could be
mm,
wardship. So you've got all these different categories of legal constructs of looking at protecting children, and the question was which one to use in that case. The other thing I really liked about this case um, was that, yeah, I mean, you could really use this to teach law in a way, because you've got statutory interpretation to try and reach the result. You've got precedent as
mm,
another factor. You've got sort of an injustice moral argument around the blame issue, and then you've got human rights arguments.
mm,
And Thorpe, in this lovely judgment, guided by you, Pauline, clearly sets it up really neatly. You've got those four different criteria for thinking through this issue. You go by
mm,
statutory interpretation. What does the actual law actually say in statute? Do you follow a precedent? Do you actually come in with a sort of a natural justice argument, almost that it's just wrong to blame somebody? And then what
mm.
does human rights have to say? So you've got these four nice different ways of looking about this case, about what to do with this child. Um, it also brings to the fore what you were saying about, for those of us old enough to remember before the Children Act, this whole thing of wardship, which is really
Mm,
complicated, isn't it? Because in a
mm,
sense, wardship, I think I'm right in saying that when the Children Act was being introduced, there was a proposal to get rid of wardship. Said, well, we don't need wardship. It's this old-fashioned thing. We're just going to have the Children Act. And then they said, no, let's just hang on to it. We might
mm,
just need it in some situations. And then it's always begged the question, well, what are the circumstances in which the
mm,
Children Act can't do what it's meant to do? And therefore, we're going to have to hang on to this weird thing called wardship, which a guy called Rob George really is the sort of the, expert thinker upon trying to think about that. Why did it matter? I mean, I think what um, the local, there was this, the the problem was, it seemed to me in this case that there was going to be, it was really questionable whether you should take this child into care, because care proceedings meant or could be interpreted or felt as if it was saying the mother's blameworthy. And of
mm.
course, actually, in this case, she'd had a tragic accident in somehow or other. So why did it matter so much that this got to where it got in court? Why didn't they just sort of say, go for a care proceeding order, and the court would have ordered care proceedings, which is what actually happened in the end?
Yeah. I
Why?
think I think
What did it matter?
I think it was about fairness at the end of the
Hmm.
day. And yes, the plan for the child was agreed come what may. And I had clear instructions from the local authority that even if the judge decided that this couldn't be dealt with within care proceedings, and therefore make a care order, and it ended up being a wardship, they would honour all of the commitments that they would be obliged to provide under wardship that they would if it was a care order case. So basically what that means is if you leave care under a care order, there's all sorts of statutory provisions that you're entitled to benefit from when you leave care. And it's things like you have a personal advisor for the next, until I think you're 25. They're entitled to things like help with accommodation, help with education. If they've been in a foster placement, they have the right to exercise the right to stay put in the foster placement beyond 18. So there's a whole raft of things that somebody subject to a care order can claim when they become 18. And I got the local authority to agree that even if the court decided this wasn't a care order case, all of those obligations would be met. So the actual outcome was going to be the same regardless, and everybody agrees that. So it did boil down to fairness. And it also, I think it also boiled down to respect for the family life, because this mother, she didn't have an accident. She basically just had a catastrophic brain hemorrhage. She literally, 1 minute she was fine, the next minute, boom. And there was no way of predicting that. There was no way of doing anything to ameliorate it. There was no way she could prepare for it. It literally just out of the blue. And when we looked at the other authorities, one of which is referred to in that case, which is the Kean decision.
Yes.
The facts in that case were quite similar in the sense that the mother in that case had been given a diagnosis of a terminal illness, and therefore she had time to plan how she wanted her children to be looked after. So she made arrangements for them to go into foster care. And Mr. Justice Kean said in that case that, you know, she'd done everything that a reasonable parent could do. She'd made proper arrangements for her children. It couldn't be a care order case because she'd acted entirely reasonably, like a really good parent should. And therefore he dealt with it in wardship. And it seemed to me that it's completely unfair that the woman in our case, for want of the opportunity to make arrangements for her daughter, was then sort of lumbered in the care order category.
So was there this sense that, in a sense, that care order was, there's a sense in the sense which it's very stigmatizing, because that word blame comes up a lot. And of course, she's not remotely blameworthy. But I thought what's really moving about Thorpe's response to that, the judge's response to that, was saying, well, that almost creates a binary between the bad parents who are to be blamed and the innocent parents, like the classic in this case, who cannot possibly be blamed. And he was saying, well, there's lots of reasons why parents end up in the care court. And I think that's kind of quite sensitive about that. He's trying to say we shouldn't be using the language of blame somehow.
Yeah, but the problem with that approach is that the statute says that the significant harm has to be attributable to the parenting.
Yeah. But
so it was all about
all
about attribution. And you know, it seemed to me that Kean had made the right decision, because he'd said, you know, this woman, given the opportunity, had made sensible, appropriate, child-centered plans for her children. Why should the woman in our case, who wasn't afforded that opportunity but probably would have done that as well, it is really stigmatizing, I suppose. And there's also something slightly uncomfortable about somebody who is represented through the official solicitor, who's a protected party, and the official solicitor was saying it's wardship. To sort of go against that felt quite uncomfortable, I think.
Right. So do you think Thorpe, this lovely judge, do you think he got it wrong in a sense?
Well, we all thought he got it wrong.
Right.
But then other people think he got it right. I mean, I think it's a good example of a case that's really literally on the line.
Yeah.
And I mean, there's another case that was reported in 2024, similar sort of facts,
Right.
but in that case, they were trying to argue it was a wardship. What had happened in that case was the mother had actually ended up killing herself and another child in a fire
Mm.
2 weeks before the care proceedings started in respect of the child who was gravely ill in hospital, and proceedings were started because obviously that child had been significantly harmed. And there was an argument to say, and I think in that case it was about whether or not you could have a threshold under Section 31 of the Children Act in
Mm.
circumstances where a parent was dead. And therefore, the argument was if there's no parent, it ought to be wardship. Whereas in that case, I think it was Mr. Justice Peel decided it's obviously care proceedings because the only reason the child was in hospital was because the mother had tried to kill her.
Yeah. So
It really
clearly,
wasn't wardship.
yeah, harm attributable to. It was quite
Yeah,
clear in that
exactly.
case. And of course,
Yeah,
in this case, in yours case, it was about future harm. Having a parent who
yes.
didn't have capacity might expose the child to decisions. So it seemed to be
Mm,
around language, almost the emotions of it. Some, as you said, the outcome everyone was agreed on. It wasn't going to make
yeah,
any difference. So
yeah.
it struck me as a really interesting case for talking about not about this is going to make a big difference in outcome, but this is going to make a difference in terms of feelings, in terms of what law's communicating, in terms of a
Yeah,
kind of a moral judgment, which is why it's so fascinating.
yeah. And also, I think from the child's point of view, children who are in care, they have what's called a life story book, and it will
Mm,
include, their story of their life, including how they've ended up in care.
yes.
And I think in my heart of hearts, I still think this child shouldn't be in care because of the statute, what the statute says. But
Yeah.
obviously, she needed to be safeguarded, which is a different phrase. She needed to be safeguarded, and if the Children Act doesn't provide that sanctuary, then that's what wardship is
Yeah.
for.
But do you think Thorpe, I've got, I think I might be on Thorpe's side actually with
I
this.
thought you might be.
Yeah, I think I am. Do you think what he's trying to, I suppose I'm thinking it because I'm thinking of all the other lots of other care cases I've read. He's trying to
Mm,
destigmatize care because you're absolutely right. It
yeah.
sounds awful because there is so much stigma too, and they're bad parents. Even though we know the vast, vast majority of children in care, there's situations of poverty, it's deeply classed,
Mm,
there's all sorts of
mm,
awful reasons why parents end up having their children removed from them. And perhaps
mm.
he's trying to destigmatize and take blame out of it. Is
Well,
that
he's
the
right.
best? Yeah.
Yeah, no, I mean, I can tell you, Daniel, being in front of Judge Thorpe was like being on University Challenge because he literally
Terrible.
banged these questions at you, and
Right.
you had to respond to all these different scenarios. One of the scenarios that he put to me was, well, what about a learning disabled parent?
Mhm.
It's nobody's fault if you've got a learning disability, but if you haven't got the right support, there is a risk that your children's needs won't be met. And we do deal with a lot of cases where
Mm.
parents have got a learning disability, and that's what happens. And ultimately, proportionate intervention has to take place to protect the child. And my response to that was, well, yes, that's entirely right. Of course, it's nobody's fault, but that is an experience that the child will have had from day dot because they will have been
Mm.
living with those parents. And therefore, you can prove likelihood on the basis of what they've experienced up to that point. In our case, there was no child protection concerns about this girl at all until such time as the mother had her catastrophic collapse. So I didn't think that that example was necessarily applicable. But I
Mm.
totally agree that we shouldn't be categorizing these people as to blame. Most of them are incredibly vulnerable. A lot of them have got mental health problems. A lot of them have got other social problems. A lot of them have been in care themselves.
Mm,
You know,
mm,
some of them don't really understand the concept of a family in the way that we
yeah.
are fortunate to do.
Mm,
So I think you always have to retain your compassion, you know, and be fair, and make sure that the process is dealt with properly. And it just didn't seem to me that classifying this as a care order case was fair. But
yeah.
I may be wrong.
No, no. I mean, I think it's about language, and I think that's why it's sort of
Mm,
really interesting, isn't it? That's why it's a
mm.
fascinating one.
It's a
Because
shame it
normally it's
wasn't
about
appealed.
because normally it's because, is the decision the right decision in terms of the, should the child be removed or not removed? And here
Mm,
it's something else going on. It's around language, which why it's a really
yeah.
fascinating. So thank you for bringing that case to my attention. It's also that classic legal point about threshold. And
Mm,
threshold is, just the most important word in child protection work in terms of human rights.
yeah.
And I think people often forget that when people think about human rights law, often forget, I think, I know lots of human rights lawyers don't think about child protection work. And yet
Mm.
the removal of children by the state from parents is one of the most hugest sort of
Well,
acts, potentially
when
violent
you
thing the state can do.
yeah, when you look at it from the perspective that um, ever since we abolished the death penalty in 1966 or whenever it
Mm,
was, the courts in this country have never been able to interfere so profoundly with a
mm,
child's life as they can by making an order for adoption, because an adoption order changes your life forever. You cease to be a member of your birth family.
mm.
You become part of somebody else's family. And we are one of the few jurisdictions that permits that to happen in circumstances where the parents aren't giving consent. In fact, it's a complete anathema in a lot of
Yes.
countries. They can't understand how on earth we do it.
Yes, no, it is, and I think
Um,
most people don't realize that the vast majority of adoptions, it's non-consensual adoption still. I
exactly.
mean,
Yeah.
90%, 90, I mean, it's, really is almost always non-consensual. It's very,
Mm.
do you find it it's quite a emotionally draining area of law to work in, isn't it? I mean, you're really dealing with some vulnerable people, the most distraught situations in people's lives.
Yeah.
It's
I
pretty
think
desperate, isn't it?
it is. I think it gives you a bit of a jaundiced view in some respects. But having said that, I think it also fosters a very strong sense of social justice and,
Mm,
you know, wanting to make sure that you get these decisions right and trying to play your part in making sure that you get them right. Because if you get them wrong, either because you leave a child at risk in a risky situation, or
mm,
you remove a perfectly safe child for no good reason. So getting it wrong on either side is
mm.
horrendous. And there have been a few cases that I've been involved in where we clearly, you know, the court did get it wrong. But on the other hand, we have a system that tolerates error
And I
because
think and as you said before, what's important about this, and I think you said mentioned this in terms of working for a local authority, is they have to make a really good case for it. They can't, the state just can't come along and take the children. They've got
no,
to go to court, and the courts are resolutely independent. And I've seen
yes,
lots of cases where if the judges don't think the local authority have made their case out, they
no,
tear a strip off them. I mean, which quite rightly so.
yeah, yes, and you know, if you look at the period of time in sort of 2013 onwards, when James Mumby was the president
Mm,
and he was making all these wonderful human rights
yeah.
based judgments. In fact, even before that, there's a classic one back in 2005 called REX, which is
Yes.
an emergency protection order case, and
Oh,
how those
yes.
sorts of
Gosh.
decisions need to be rigorously conducted. Um, yeah, I mean it is. it can be emotionally draining, obviously. And when you've got a family of your own, you know, you hold them closer to you sometimes because of it. But I think ultimately it's really important work. And I just think
Right.
that it's very interesting. You know, you have to acquire a range of understanding of different disciplines. So, for example, I've cross-examined a pediatrician, a radiologist, a neuroradiologist, a
Wow.
social worker, I don't know, you know, a whole range of professionals. And in order to work out what questions to ask, you've got to have a vague understanding of what it
Ouch.
is they're on about.
Right.
Sorry if
Yeah.
that was my dog.
Right. So I'm conscious of time, so I'd really like to invite your colleague Melissa to join us. Melissa, do you want to turn your camera on, please, and say hello and
She's all right.
introduce? Hi.
Hi, good
Hello.
afternoon, everyone.
Hello, Melissa. Hi. It's wonderful that you can be here as well. Now you're working with Pauline. Do you want to describe what's your job title at the moment, Melissa, to a group of people, many of whom are first year law students?
So I'm a pupil at One Crown Office Row, Brighton, so specialising in family law. And so I'm currently doing what's called a pupillage. And essentially what a pupillage is the practical training that you need to complete under the supervision of a pupil supervisor in order to then practice as a barrister. So you do pupillage after you've finished your bar course.
And thank you. And do they does your pupil master give you a bag at some point at the end of it or something? I mean, embroidered, does that still happen?
A bag? I didn't know
So,
about this.
I don't know. I don't know. Pauline, am I making this up or I remembered
Well,
something
do you
wrongly?
know what? No, you haven't. But I tell you what, I when I transferred to the bar and I was doing a very, very long case where I was being led by a KC or QC as they were then, and he at the end of it said to me, "What are your initials?" And I thought, why on earth is he asking me that? And so I said to him, well, why do you want to know? And he said, oh, I've got to fill out something or other. And I thought, all right then. So my middle name is Marie. And so consequently, my initials are PMT, which in days gone by stood for premenstrual tension. And then
Right.
about 3 weeks later, he produced, I've got it here somewhere, I don't know where it is at the moment. I've got what's called a red bag,
That's
which has got the initials PMT emblazoned across it, which is it's a gift from King's Council to their junior as I
ah,
suppose, as a sort of, I don't know, a thank you or I think it's something to do with, you know, making you feel good about yourself. I
right.
might get Melissa a bag from Waitrose tomorrow if you like.
That.
Melissa, right. Well, we've settled that point, which is helpful. Thank you.
There is a blue bag though. You're right about the blue bags, but I've no idea what that's for.
Melissa, did you always know you wanted to be a barrister, or how did you reach that decision? And
Well,
why?
I always had an interest in the law, but I didn't actually do a law degree straight away. I did an English and related literature degree at York University. And I remember thinking, well, I didn't do law for A level. So I thought, well, if I still definitely am interested in law and definitely want to go down this route, and that's what I'll do after the English literature degree. And so then that's when I did a law conversion course, which was the LLM, Law and Legal Practice. And then along the route, I did work experience at different solicitors, so work experience at family solicitors, and I also worked as a paralegal in the court of protection.
Wow. And then
And
you
yeah,
decided on family law.
yes, so I was really interested in family dynamics, and I'd had some experience in family law, volunteering for the BPP Family Advice Clinic, which is kind of a free pro bono advice
Yes.
service. And just the family area of practice really interested me because I just found the cases and results appeared more tangible. I just felt like an advocate could make a real difference in such stressful and difficult times for clients.
What would you say is the best thing about what you're the thing you enjoy the most, and what's the bit that's terrifying, stressful? What's the best and the worst aspects of what of your job at the moment?
I suppose I suppose part of the best and the terrifying bit is just getting up and doing some advocacy. So
Right.
what's going to be, I suppose, the most
And just,
exciting part?
so, and does that depend on the judge? Are some more terrifying than others?
There definitely are probably some who are more terrifying than others, just from what I've probably observed. And I've been able to view lots of barristers deal with it very well and learn not to be intimidated if the judge is firing out questions at you, because at the end of the day, they need you to help them through it as much as you're trying to put forward your submissions. So you try to be as clear and straightforward as you can so that the judge can then come to their decision at the end of the day and see,
Yes.
I understand the point you're making.
Yeah, and I suppose, as we said before, it's important to remember they're asking difficult questions because you're asked, they're making difficult decisions and they want
Yeah.
to make the right one. And part of advocacy is about clarity and precision. There's a question in the chat specifically for you, Melissa, which someone's asked, what tips from Alejandra saying, what tips do you have for someone wishing to go down the barrister route at present? Because it goes on to say it seems to be very tied to finances and networking. So what tips would you give to anybody wanting to go down the barrister route?
I think definitely in terms of tips, in terms of when you then later go on to apply in your applications, definitely try and get involved in as much pro bono work and volunteering. I know that there's one volunteering service called Advocate, which looks for casework volunteers, which can be really helpful and a great thing to put down in your applications. Try and also sign up for mini pupilages, which essentially work experience at a chambers for a couple of days. But also, Chambers isn't just interested in your legal work experience. Make sure you keep up with all your hobbies as well.
Right. I imagine reading lots of novels and getting involved in literature. It also helps the study of law. At Birkbeck, we definitely favour encouraging the overlap between literature and law. Certainly lends itself to family law in particular. Couple of questions coming up in the chat, which I just want to read. So anybody listening who wants to put a question, if you'd like to put questions in the chat now, that would be great. I'm conscious of time. Dora Distri is asking a really interesting question. Is the role of a barrister changing because of AI and the AI framework, or will it be needed more than ever, especially in your field of law where vulnerable groups are involved despite it? If it's changing, how is it changing? And what would you still like to keep from the AI framework? I feel as if in the last 6 months, these conversations about AI have absolutely sort of catapulted up. I thought I'd be able to retire without ever having to worry about AI. And I think I've got that one wrong, actually. But so where do you see, I mean, this is to both of you, because I think it's such a key issue. Where do both of you see the role of AI in practice?
I think things will start to move off of online because of AI. So we'll start to have a lot more hearings in person rather than remotely because of now issues with, I suppose, security with AI.
Right.
What would you say, Pauline?
I don't know, actually. I mean, I think I can envisage situations where people might use it to draft documents, but I don't think that would be any substitute for you checking that the authorities that they are using is the right ones. I mean, I'm hoping it doesn't do too much damage in the rest of my career. I mean, I must say, actually, in terms of the years of my career, I know this isn't AI related necessarily, but certainly electronic evidence has become absolutely crucial. And, Melissa sat with me on a case that I did in November ended up being about 5 weeks. And if we hadn't had access to mobile phones records showing communications between people who weren't supposed to be communicating with each other, I think it would have been quite a different outcome potentially. So certainly technology, electronic evidence is really, really important. I suspect AI will further that even more in the coming years.
Yeah, it's interesting to hear. I know lots of Birkbeck students, quite a few of them actually work in IT and have all those sorts of skills, and I think they're going to be really useful in when they move into law.
Extremely useful. I mean, just little things like, I mean, where Melissa really helped me in the case that we were dealing with. You know, there are some social media platforms that I have to say are completely alien to me. But, you know, if you don't understand, for example, how Snapchat works, you can't necessarily understand the evidence that's in front of you. And because Melissa is more familiar with those sorts of tools, that was a really, really massive help. So I would say that, you know, the day-to-day skills that a lot of young people have got are really, really important in the context of day-to-day practice. And you probably don't even realise it.
No. It reminded me when I was doing some research with young people in the care system, we were talking about this expression letterbox contact. You know, the idea of writing a letter, putting it in a letterbox was just utterly meaningless. And it really begged the question of, is Snapchat direct or indirect contact? So a lot of the certainties in law really get thrown up because of people engaging with it. So there's, you know, it's interesting. I want to ask another question that's come up in the chat by Ella, who's saying, and this is to you, Pauline, if you could somehow go back to the beginning of your career and change onto the barrister path earlier, would you? If so, why? And how did your solicitor work set you up for barrister work, if at all? I think you answered the latter part of it, but do you regret leaving it so long, Pauline?
No, I don't think I do. I mean, I was, how old was I? I was 46 when I left my partnership. And I think that I just about timed it right, really, in terms of having enough time ahead of me to be able to establish myself at the bar, and also had enough time behind me to have established myself as a solicitor, as a platform to become a barrister. So I'm sort of thinking that having done 22 years as a solicitor, I might end up doing 22 years as a barrister, and then I'll be done. So that'll be fine.
Right. I mean, I think lots of people do different careers. We had a couple of law students at Birkbeck I know were local authority social workers, and then they moved into the law. So you know, there are lots of interesting moves and directions that people move in.
I've got colleagues who were former social workers. I've got a colleague who was previously in publishing. I've got another colleague who was running her own business. I think actually coming to the bar after a career is no bad thing. That's not to say people shouldn't go for it when they're young as well, because having more energy is probably helpful.
No, it's really encouraging to hear that, particularly for, you know, a lot of Birkbeck students listening, you know, will be doing all sorts of jobs and will be possibly slightly earlier. There's a question from Salvi here, which I'd like to ask to both of you, which is, how do you foresee the legal landscape evolving in the next decade, particularly concerning child law? So it's a rather wide-ranging question, but where do you think it's going to go to? What are the big challenges ahead? Pauline and then Melissa.
I don't know. I mean, gosh, that's a really difficult, brilliant question, but really, really difficult. I mean, I think we've seen so much change in the last 10 years that it's kind of hard to see where things go beyond that. And well, what I mean by that is particularly in the field of adoption, for example, we had the Adoption Children Act come into force in 2002, and what that did was introduce this concept of a placement order, which we didn't have before, and it meant that the court dealt with the parental consent at a much earlier stage, at the end of care proceedings. And it also got rid of this horrendous statutory provision from the old Adoption Act, which was 1976, which basically said that if a parent withholds their consent to the adoption of their child, they are unreasonably withholding their consent. I can't think of anything more reasonable, quite frankly. So that the test changed to the welfare of the child, requiring the parent to give their consent, for their consent to be dispensed with, which is a much better way of putting it. And we've had a lot of jurisprudence in the field of adoption that is now much more open adoption. So we're heading, I think the next phase, on your point about indirect contact and stuff like that, is that we're going to have much more open adoptions. We often have cases now where the care plan talks about contact that's more sort of social media based. So, for example, a parent might make a voice note and that's then played to the child, not necessarily in an adoption case, but in a care case. So I think there'll be a lot more use of a lot more flexibility about how we approach things like that.
Melissa, is there anything you'd think you can see emerging from your vantage point as is going to be there for a lot longer?
It's difficult.
In the decades ahead.
Probably following off Pauline's comment with regards to contact, I think there's becoming a lot more emphasis on maintaining contact between siblings in particular, in families, trying to ensure those carry on, because those are bonds which can last forever. So I can't think of anything off the top of my head.
I want to ask, sorry, carry on.
I know, it was more of just a side point. I know someone mentioned about finances. If you look at the inner temples, there's Lincoln's Inn, Gray's Inn, Inner Temple, Middle Temple. A lot of them have scholarships available for the GDL and bar course. So that'd be a good thing to look at.
Yeah. There is I see there's other questions coming in, but I think we'll have to come back to them later. Or rather, we don't have time to go through all of these questions. But I just wanted to, in our last few minutes, the question that we always ask our guests on this legal practice conversation is, it's a bit like the desert island, what are you going to take with you question to end with. So I'm going to ask this of both of you. I'm going to give you all power as a legislator. You can introduce one law. You can do whatever law you want. You have a power to introduce a new law or change something in the law. What would it be? So start with you, Pauline. What would you like to see? You have absolute power.
I don't know about a new law, but I would like to see a public apology for all the women in particular who were subject to forced adoptions in the 1940s, 50s, 60s, 70s. Along with the countries like Ireland have done it, I think Australia have done it. We haven't done it. And if I had a magic wand, I would make that a legal impediment for this government.
Thank you. And Melissa?
Imperative, I mean, not impediment.
Yeah. What would you like to see happen?
Oh, it's very difficult question. I can't think of specifically. It's
all right. Well,
I suppose just thinking about transparency at the moment in courts. So looking at how and ways which courts can continue to be more transparent and looking at open justice.
Yeah. That's a really interesting development in family law, isn't it? It's really critical. There's been just one question coming up. We're going to end sort of now, but there's one question in the chat just come up saying, your journey to becoming a solicitor or, barristers, did academics play the primary role, or did work experience and extracurricular also contribute significantly? Feel free to, do you think going out, and there's other questions that are really saying, emphasizing your point, Melissa, about experience and volunteering and stuff. So I wonder how. as a barrister, do you think actually reading the case law and engaging with academic arguments is critical to it, or is it the experience that you really need, or is it just the mixture of both, really?
I think definitely a mixture of both, but I think experience definitely lends to whether you want to go into be a solicitor or whether you want to be a barrister. So I think it's good to go and do work experience at like solicitors firms and have a go at doing advocacy. And I think with me, probably a lot of my hobby in terms of acting probably came to play a lot with why I was more drawn to the advocacy side of things. Being a barrister, I probably like the sound of my own voice quite a lot.
Well, that's wonderful. That's great. Well, I hope your parts are flourish. And Pauline, you think sort of you said you like being a barrister because you like doing the law.
Yeah, I do.
Vicky.
And I just like the autonomy. I like to think I'm completely independent. I can do what I like. I don't have to answer to anybody. I fight my cases and I go home, basically. I think what I should say, though, young barristers will probably have a totally different experience because they get sent to all these far-flung places here, there, and everywhere. That hasn't been my experience, and it probably would have been had I been, junior. But the older you get, the more experienced you are, the more kind of autonomy you have to sort of say, well, I'm not going to do this, I'm not going to do that. And if you've got enough work in your area where you work, then why bother? Why travel if you don't have to?
Yeah.
And if the work's interesting.
Yeah. Well, thank you, Pauline and Melissa, both very, very much. I know there's other people who've got some questions coming in, but we are out of time. So thank you both so much for joining us this evening. It's been really great talking to you. Thank you very much.